We're at 11 o'clock, so top of the hour. Welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over the case today. I have joining me on the panel Judge Harvey J. and Judge John Harris. We have the case of Weishart versus Weishart. I'm going to assume that the appellant would like 5 minutes of rebuttal unless you inform me otherwise. The clock will be set appropriately by our marshal. And Mr. Tyson, you may proceed. Just make sure if anybody has any noise making devices, you silence those. And for just the best practice would be to mute your microphone if you're not speaking. So with that, Mr. Tyson, you have the floor. You may proceed.
May I please the court? My name is Brandon Tyson. I represent the appellant Kelly Weishart in this matter. The issue that's on appeal is the trial court's error in not enforcing a marital settlement agreement that the parties entered into. The facts are largely undisputed in this case. I think that the judge actually said that during her ruling. The issue was how the judge misapplied the law in this case. And the facts are like I said, relatively straightforward. The parties entered into a marital settlement agreement in 2012. That marital settlement agreement required that the husband execute a quitclaim deed transferring all his interest in a particular piece of real property within a 60-day period to the former wife. That was the contract provision. It was clear. And there was a provision that said if he failed to do that timely, that he would have to pay alimony for 20 years in the amount of $800 a month. And the trial court judge, properly so, determined that while it was called alimony, it really was a contract.
Counsel, was there any specificity as far as who was to prepare the quitclaim deed?
No, there was not. That issue was not
addressed. Who did prepare the quitclaim deed?
I think that was a disputed issue. I don't know if the judge ever made a finding as to that. I think that was disputed back and forth as to who prepared it. But I assume when you're saying that I assume you're referring to the 2013 deed, because there was two deeds signed. The first deed was in 2013, which transferred the property from former husband and former wife to former husband and former wife as joint tenants with the rights of survivorship, which was a deed signed but didn't comply with the terms of the final judgment in the marital settlement agreement. The former husband subsequently did execute an appropriate deed in accordance with the agreement, but that was several months after the wife had initiated the enforcement action.
That was
I'm sure I saw it in here somewhere, but where does it say it has to be done within 60 days?
Hold on, I could pull it up it was in the marital settlement agreement. I'm reading paragraph. It's in the motion for enforcement as well. It says the husband agrees to immediately transfer any and all interest in said new marital residence to the wife by signing a quitclaim deed within 60 days of the closing on said new marital residence, currently scheduled for November 13th, 2012. So that was an issue.
Where is that in the MSA? What paragraph?
Paragraph 12.
Okay, so it's not in the alimony paragraph that talks about paying
traditional
alimony.
Yeah, no, it's in a different paragraph. And on appeal, we're not disputing the trial court interpretation that it was a penalty provision or a liquidation damages clause. I think that's probably accurate. I mean, the parties called it alimony for what reason, I don't really know. But the fact of the matter is, whatever you call it, it's monetary damages that the trial court was required to enforce and enter a money judgment. The trial court.
That's kind of an important distinction, though. Is it alimony? Is it liquidated damages? Is it just to be coercive until he does sign the deed? I mean,
no, I think it's contract damages. I think marital settlement agreements, as Your Honor knows, are contracts just like any other contracts. In fact, they're highly favored because people do so often in the context of dissolution of marriage cases. And so it was a contract. You can call it whatever you want. The reality is, substance over form. And clearly the contract, which was unambiguous, said he didn't deed the property over in 60 days, this is what he's paying. The term enforcement, its significance really comes into context in an enforcement and what remedies the trial court had. The trial court made the error in this case by saying, oh, the issue's moot. If the issue's moot, he signed the deed. The issue's moot. If you want to, try to seek damages or enforce this contract and get a judgment, you got to go to circuit court. She felt that family court, albeit a circuit court as well, was not the appropriate avenue to seek enforcement, and that's error. I mean, there's ample case law that talks about situations where parties have come back after a divorce case, after a final judgment has incorporated a marital settlement agreement and sought enforcement. I cited a case in my brief that talked about a situation where a circuit court that handled domestic relations enforced a promissory note. This situation's a little even more clear cut in that you have an unambiguous agreement that was never appealed, never set aside, was adopted into a final judgment, and the former wife sought to enforce it. And so while the trial court did not find it was contemptible, and again, that's not something we're disputing, what we are disputing is that she was entitled to a money judgment, and she could then enforce it, as a creditor would be in a traditional contract or equitable distribution setting. That's the issue on appeal. The issue is the judge in making her ruling. First, she found that the actions of the former husband were not willful. Well, that's a finding that, could have gone both ways, but regardless is irrelevant to the issue on appeal. This is a simple situation where the former husband breached the contract, breached the terms of a contract, which was adopted into a final judgment of the court. His willfulness is irrelevant. That's irrelevant under the circumstances. She was entitled to a money judgment with interest and so forth at attorney's fees pursuant to the agreement. The other ground that the trial court judge found in denying enforcement was that there was a 10-year delay in bringing the action. So while the trial court didn't use the term, I used it in my brief, latches. That seemed to be the defense, which former husband.
Court did use that term, didn't she?
I believe she may have used. I don't think it's in her. It was in her judgment, her ruling, in a written ruling. She may have brought it up when she was kind of talking about the case and discussing, the grounds.
It's in the transcript from the hearing.
Yeah, but it wasn't in.
Mr. Tyson, you're a little muted.
Can you hear me? Can you hear me fine?
You died off there. Yes, we can hear you right now.
Okay, sorry about that. Yeah, I don't believe it's in her order that she ultimately signed, which is on appeal. And so assuming, that's the defense and that's the grounds, obviously, as we all know, latches is sort of a two-pronged, issue. First, you have to have a delay. Let's assume there was a delay, 10 years. That's a delay that would be sufficient for latches. The second element is you have to find some prejudice, and the trial court never made a finding of prejudice. The only conceivable prejudice in this case would be that the former husband now has to pay this money judgment that he otherwise, wouldn't have had to pay. And the case law that I cited extensively in my brief talked about having to pay a judgment, in a delayed fashion is not in and of itself prejudice. So even if the former husband had properly pleaded the defense of latches, the court didn't make the proper findings, and the facts wouldn't have substantiated any such finding anyway. So, the issue and where the legal issue comes in is basically at the hearing, the former husband primarily argued, well, you can't hold me in contempt. You can't hold me in contempt. This isn't a support obligation. Again, that was his primary argument. And again, I think that's irrelevant to the appeal, because we're not suggesting, this is alimony in the sense of a support obligation. The argument is that he is not entitled to enforcement, and the former husband's argument was, oh, the agreement was unfair. It didn't have a refinance provision. And again, maybe he made a bad bargain. I don't know. None of us were there. But case law is abundantly clear that bad bargains unfortunately happen. And the court, regardless of a potential bad bargain, still has to enforce it. And as a matter of law, the former husband was precluded from trying to argue that the agreement was unfair or that the agreement was not enforceable because the agreement was adopted into a final judgment. And
Mr.
that's an
Tyson,
important.
if assuming we agree with you that it should be sent back down to the trial court for the family, for the trial judge to readdress the enforcement of the MSA, is it also appropriate for the trial judge to consider the position of the parties now in light of the passage of almost over 10 years and determine the equities of where the parties stand now with regard to all of the financial obligations as part of the MSA?
I don't believe so. Not under the circumstance of somebody trying to enforce a marital settlement agreement as far as a contract on a contract basis. The financial circumstances of the parties would only be relevant with respect to arguably some sort of defense that the former husband can make. But like I said, the fact that he now has to pay these damages, which are exceptional. I mean, they are a little under $200,000.
Well, that's in addition to basically paying for the house and signing over as far as the sale of the previous home as well. I mean, it seems to me like there's an awful lot coming out on one side of this contract, marital settlement agreement, and not a whole lot coming from the other side.
Well, again, we can't, go back in time and figure out why the parties agreed to what, but we know that there was a house, and for whatever reasons, I don't know what the consideration was on the other side, but there was an agreement that the husband was supposed to transfer the house to the wife. Now, I assume there was other consideration. That agreement was adopted by the court. Husband never, tried to set it. He never appealed it, never set it aside. So that was the agreement. The parties agree that this was going to be the penalty provision. And
Tyson, would your position be the same if Mr. Wishart had signed the appropriate deed on the 61st day? Is he still on the hook for $192,000?
Well, I guess the question would be probably whether time was of the essence. If it was the 61st day.
A breach is a breach, right?
A breach is a breach, but the issue is whether time is up. I mean, there are excuses to.
So equity does come into play here?
I don't think equity comes into play in this case. I think it's an issue of what the facts and circumstances were. The problem what the former wife had is her property was inalienable for, I guess, 9 years. I mean, technically 9 years, she couldn't sell the property without.
She ever tried to during those 9 years?
The record doesn't reflect any efforts, and the record reflects that she found out about this issue when I guess she went to sell it, and I guess a realtor told her, "Hey, your former husband is still on this property, and he has to convey the property."
So what was the prejudice to your client from day one until year 9?
The prejudice to her was again, she had a property that was encumbered, inalienable.
But what was the prejudice?
Yeah.
She didn't try and sell it. So she was, using the property
Okay, but
without any encumbrances. And her former husband was paying for the servicing of the debt on the home too, correct?
I don't know. I believe she was paying the mortgage. He may have been on the mortgage. Those circumstances, were not part of the court's findings. But I know regardless of whether she sold it 9 years later, she was prohibited from selling. So the fact that she decided to sell it 9 years down the road didn't take away the fact that she couldn't sell it 3 years earlier. And I kind of circle back to my original argument, this is a contract, an enforcement of a contract that was adopted into a final judgment. The relevance of prejudice would only be in relation to a laches defense on the part of the former husband. And that's where the prejudice, if any, would lie. But he wasn't able to show any prejudice under the eyes of the law. So,
Mr. Tyson, let me ask you about latches. It's your position that that defense was waived?
I don't believe it was waived. I think it wasn't asserted, I guess, affirmatively, but I think it was brought up by the trial court judge. It was indirectly brought up by the former husband. So I don't believe it was probably waived under the circumstances.
Well, and I ask about that because there's some insinuation that maybe that was part of the argument, but your position here today, it was not waived. And the reason I ask is this was a motion for enforcement, correct?
Yes, sir. And
we all know that a motion is not a pleading. So there was no obligation on the former husband's part to plead to the motion for enforcement, correct?
that's correct. But I still think he would have to raise the issue at the hearing for the trial court to address it. If you're claiming some sort of equitable defense, I think you've got to raise it as an issue for the trial court, especially when there's findings required.
Well, he did raise an unequitable defense, did he not?
He raised an issue basically that the agreement was unfair. I mean, the primary crux of their response was arguing against the contemptibility of it. The former husband didn't raise this issue of latches. The trial court, from the evidence that was presented, she sort of, like Judge Harris brought up, she's the one who first used that word latches. I don't think the former husband ever used it. But regardless, whether the former husband, pled it or raised it as an issue, the facts in this case don't substantiate the secondary prong, which is prejudice. The only prejudice, like I said, arguably would be the fact that he now has to pay something later rather than sooner. But that, under the Florida law, is not prejudice. I would like to reserve, unless any of your honors have a question, I would reserve the final 3.5.
Okay. All right. Counsel, and I'm not Apology, is that correct? Did I get it right? And you're on mute.
My apologies. Yes, Your Honor, that is correct. Jim Ippoliti on behalf of the appellee, Jeff Wishart, who is viewing with the live stream. The first issue I want to address, Your Honor, is the standard of review. Within the initial brief, appellant argues that it should be a de novo review when the case law is very clear that court reviews orders on motion for enforcement for abuse of discretion. It's our position that's abuse of discretion case, not a de novo case. And we cite to the identical cases that he cites to Farid versus Raba in the course in the case that relies upon.
The judge determined that she didn't have jurisdiction to enforce this. Is that a legal question?
No, I think that the judge did have jurisdiction. In fact, I think she did rule on all of the issues. She just brought it up that, hey, this is, this might be out of my realm. However, she did rule on all of the issues before the court within the order, and we can get to that as we go through the items. So I believe that this court did properly assess the credibility of the witnesses, the facts before it, the evidence before it, and did rule on all pertinent issues. I want to be clear that the husband's requirement in all of this in the MSA is for him to sign a deed. It's not as the initial brief of the appellant says that he needs to transfer all of his right, title, and interest into real property to the former wife. That is not at all what the MSA said. He has to sign a deed.
Well, he has to sign a deed.
Actually, it says, should the husband fail to quit claim his interest?
Correct.
Does it not say that?
It does. And he did quit claim his interest, Your Honor. He was provided a document.
Well, and respectfully, counsel, you just said that all he had to do was sign a deed, but it sounds like the MSA says the husband had to quit claim his interest.
Correct.
In the party's new marital residence, correct?
Yes, the actual language says the husband agrees to immediately transfer any and all interest in said new marital residence to the wife by signing a quitclaim deed within 60 days of the closing of new marital resident currently scheduled for November 13th.
I think Judge Jay and I are looking at paragraph 9.
Yes, I'm looking at the end of paragraph 9, which is the penalty provision.
Sure.
Should the husband fail to quitclaim his interest in the party's new marital residence. That sounds like more than signing a deed, does it
Okay.
not?
Well, Your Honor, let's look at the exact words. Should the husband fail to quitclaim his interest in the new party's in the party's new marital residence? He did that. It's uncontested that he did sign a deed. There's
No,
no,
but he didn't convey his interest. He retained his survivorship interest, didn't he?
should the husband fail to quitclaim his interest in the property? He did quitclaim his interest. He quitclaimed it to himself and his wife. Again, in a deed that he did not draft. He merely was provided that deed and he signed it.
Well, on that deed where it says, you know, the information for the drafter, it's the same address that the husband has.
Sure.
Don't you
Yes.
infer from that he's the drafter? Same,
No, I
same
would not infer
handwriting,
that
same
at all.
address.
The testimony of at the trial was very clear that he did not draft it, Your Honor. He signed what was provided to him. So that was before the court. The wife did not remember who drafted it. The husband specifically remembered that he did not draft it. So it doesn't say this in paragraph 9, Your Honor, it doesn't say that the husband needs to quitclaim his interest in the property to wife. It just says he needs to quitclaim the property, which is what he did. Doesn't say must quitclaim his interest in the property to the wife. It says that he must quitclaim it. Exactly what he did. By the letter of this statement, he fulfilled that obligation.
It's kind of an
But
absurd
real-
interpretation of that paragraph, isn't it, sir?
I don't believe it is, Your Honor. It doesn't say to wife. It's very clearly written out in paragraph 12 that he must transfer.
What if he deeded it to his parents? Is that
It
okay?
would satisfy obligation number 9, paragraph 9. It would not satisfy obligation number 12. So, Your Honor, the crux of this is the deal was there was this new house. I am going to transfer this new house to you. Wife will end up with this new house. If for some reason I don't transfer that house and you don't get that house, that value, we'll instead put in this alimony where I'm going to pay alimony instead of this equity. This was an equitable distribution of the house. Wife got the house. If he didn't satisfy, if the wife didn't ultimately get the house, the money attached to the house, it would instead be made up in alimony. But she did get the house, Your Honor. She did get the money from the house. That is uncontested. The transfer, again, he's not an attorney. He was provided a document that says, this is the quitclaim deed that you need to sign. He would have known, he's not an attorney. He wouldn't know a joint tenants with right of survivorship. He was given a document, he provided, and he signed it. The court was very clear that this happens all the time, that clients are provided documents, they're told to sign, they do so. He relied on legal counsel, which he had, and that's exactly what was done. So it's not, again, it's not the husband's responsibility for the content of what that deed is. That was up to the wife. The wife got that deed.
How is that up to the wife?
It was her interest in the property that she was gaining. That was
No,
recorded.
it was his interest that she was gaining.
Correct. But once that deed was executed, she owned the property. It was publicly recorded. She had 10 years in which to realize that perhaps there's something that the attorneys did or that she drafted. We're not sure whether it was her or her counsel, but we know that it was neither the husband or his attorney that drafted the deed. It was believed to be that it was executed properly, and that argument wasn't brought up for another 10 years, in which case, when it was, the new deed was signed. The trial court correctly held that there were 2 deeds that were signed, both of which former husband believed satisfied his requirements under the MSA. And no one, until this action started last year, was aware that it didn't do exactly what it was supposed to do. And as the discussion was with prior counsel, it would be a windfall for wife to The contemplation was you get the house or you get this payment. She got the house. She got the payment. There's no prejudice to her. She got everything that was negotiated within the MSA. The motion for contempt. Remember, this is a motion for contempt and enforcement. They have now said we're not going to appeal the motion for contempt. So that's not before the court. We are just under the provisions for enforcement, but they were pled together. It's for contempt and enforcement. So it's our position that it wasn't uniquely brought as an enforcement action. So
Why does that matter? I mean, you would agree that they sought enforcement. She sought enforcement, correct?
correct, Your Honor, and it was the court determined at that issue that the enforcement was already done. The deed was signed back in 2013. And the corrected deed was signed in 2022. It provided exactly what it was that the MSA was designed to give, which was the home to the wife. And that's exactly what it did. And we can go through the court's ruling. Respondent did sign, and this is the trial court's order. Respondent did sign 2 quitclaim deeds as required under the marital settlement agreement. The respondent assisted in the refinancing of the petitioner's home formal marital residence, and the issue was not raised at that time. That the alimony penalty triggered back to the property division under settlement agreement, which is factual because, again, this was the house. If you don't give me the house, we're going to have alimony. This was an equitable distribution, and this alimony trigger was in the event that transfer of the property didn't occur. There's sufficient case law that holds that if the trial court had proper factual basis and legal basis, that it should not be disturbed on appeal. And those are all cited within our case, Zach versus State, where the rulings are fact specific, like we have here. Appellate courts are more prone to defer to trial courts to make such decisions. This is because trial courts are in a better position to assess the characteristics of testimony or other evidence they admit. The Williams versus River Bend of Cocoa Beach case held that an appellate court will not disturb the trial court's findings of fact in a non-jury trial where they are supported by competent, substantial evidence, even though contrary evidence was presented.
Well, isn't it counsel, isn't it a legal analysis whether the husband failed to quitclaim his interest in the party's marital residence? Isn't that a legal analysis?
I don't believe it's a legal analysis. I think it's a factual analysis, because it's uncontested that a quitclaim deed was drafted. It's a factual analysis of whether that quitclaim deed was sufficient to transfer the rights in that property.
That sounds legal to me. I'll be candid with you. I understand the point about whether or not he did it, but the import of it strikes me as legal. Is it not?
My position, Your Honor, is that it's not. It's if there was no quitclaim deed done, or there was a different argument, that's fine. But the quitclaim deed was drafted, again, presumably by wife or wife's counsel, specifically not husband or husband's counsel, as was the testimony.
But I also don't see intentionality. I don't see unclean hands in this sentence. It just says, should the husband fail? It doesn't say if the husband did something intentionally, did something deceptively, conspired with someone. It just says, should the husband fail? You would agree that's the language of the sentence, correct?
I do agree with that, with the language of the sentence. But, Your Honor, what I'm saying is that with the husband, he did quitclaim the deed. He didn't fail to. He quitclaimed the deed. The fact that
why was the second?
Flawed,
Why was the second quitclaim deed necessary?
because the first one was flawed, unbeknownst to either of the parties. It wasn't until a realtor, when the property went for sale, said, "Oh, wait a minute, this deed didn't do what you thought it did," and that was corrected. Again, no prejudice. The trial court held 3 different separate holdings that all support its findings. First, that there was no willful conduct. Second, that the motion was moot. And third, that it's an issue of equitable distribution, which is correct, because again, the house that was an equitable distribution. And if she didn't receive that equitable distribution, it would be fixed or made up to her in the form of this 20 years of alimony. We also have a Tipsy Coachman Act doctrine that comes into play here, Your Honor. One has already been discussed, that we've got an issue of potential latches or the waiting of 10 years to bring forth this claim, which benefited only one person, wife. If it was brought up back then, hey, this deed doesn't look right, it could have been corrected back in 2013. The second is a subsequent agreement, and this was discussed within the trial. There's a written
Let me ask
agreement.
you quickly, counsel, about latches. As you heard, and as you read, the argument in response to latches is there was no prejudice. The prejudice prong was not met here. What say you to that?
I would say there's a huge prejudice, Your Honor. The contemplation of the parties at the time they entered into this contract was, we are going to divide up our assets. In that division, wife is going to get the house. And if for some reason husband doesn't play nice and doesn't go along with giving wife the house, then we're going to penalize you by give us money instead of the house. Well, she got the house, Your Honor. So the prejudice would be my client would pay twice. He would pay for the house as well as the alimony. That wasn't contemplated by the parties. It was contemplated if the wife didn't get the house, we're going to get these financial damages. So there's where the prejudice occurs, Your Honor. It would be a double payment by my client, and it would be a double receiving of this asset, both the money and the home and the money by wife. So there's where the prejudice is. So there was a subsequent agreement that was discussed. It was signed on November 6th of 2014. So back towards the beginning, written agreement whereby specifically says, I, Kelly Parrish Wishart, and Jeffrey Wishart hereby agree that as of November 6th, 2014, that any and all alimony payments are now terminated. Very clear contract language, accord and satisfaction. Wife acknowledged this within the testimony. So it was before the court. The court didn't rely on it, but under Tipsy Coachman, as long as an appellate court can affirm a trial court that reaches the right result but the wrong reason, as long as there's any legal basis to support that judgment on the record. That's Robertson versus State, Florida Supreme Court case. So we've gotten accord and satisfaction, Your Honor. So although it wasn't mentioned in the trial court order, it could have been relied upon because that accord and satisfaction basically eliminates the marital settlement agreement, section 9, alimony. We hereby, any and all alimony payments are now terminated. So that would be section 9, terminated. So the whole discussion of, well, how does the language of 9 versus the language of 12, how do they coincide? Section 9 is knocked out as of November 6, 2014 by signature in writing of the parties, including the former wife. So court could have relied on that. So Tipsy Coachman is going to apply here. Your Honor, it's a very simple situation here. We've got an equitable distribution of this marital home. And they put a safety net in the event that husband didn't allow wife to own this home outright, which he did. It was done improperly by a deed that he did not draft and his counsel did not draft. It was corrected when it was found to be a problem. So again, there's no harm, no prejudice to wife, but a tremendous harm and prejudice that would come back to the husband because she's double dipping. She's getting the reward up front and also getting the penalty. If she'd have said something back in January of 2013, hey, hold on a second, this is not drafted. The terms of this quitclaim deed are not proper. There would be no prejudice. They could have been corrected right then. You can't sit on your hands, Your Honor, and then say, oh, well, now we want 10 years of alimony payments, 20 years, actually. They want 10 years that have accrued so far and another 10 years. Because we kept silent, because we sat on our hands and kept this little secret that this deed that you signed is incorrect. we now should gain a financial benefit of $200,000.
Is there any testimony in the record that shows that the wife was aware that the deed was incorrect during those initial 10 years?
Wife doesn't recall anything of the
First time she learned of it was from the realtor prior to the closing, right?
That's the testimony, yes.
Okay, so that's in the record that indicates she was not aware of it the whole time. She wasn't, as you just accused her, sitting on her hands and playing games.
No,
Your guy's the one on the hook for $192,000 and he's just going to sign whatever's put in front of him? And we're
Yeah,
supposed to
legal-
give him a pass?
No, Your Honor, he had legal counsel and he relied on the legal counsel to say, hey,
That might be a problem
need to
between
sign
him and
this
his
deed.
counsel then.
I don't believe so, Your Honor, because the deed did transfer his interest, and I agree, it did not transfer all of his interest to wife. It did transfer an interest in the property to his wife. It's a joint tenants with right of survivorship is an indivisible 100% of that property. So he did transfer all of his wife, but if wife had died during these 10 years, then it would be a different situation. But if he had died during those 10 years, he would have transferred all of his property. That would be, the deed would have been proper then. But because it was what he believed and what she believed, both parties, to believe properly executed deed transferring his interest in the property, and nothing was done for 10 years. There's some liability that falls on both of the parties, but it's a recorded deed, Your Honor. At any point in time, wife's counsel, wife's real estate broker, anybody during those time, if she wanted to sell it in year 6, or year 3, that could have been notified and said, "Ooh, wait a minute, this doesn't say what you guys thought it said." So again, it wasn't contemplated by the parties that if he was given an improper deed, he's going to get penalized. It was contemplated by the parties that if wife ultimately doesn't get this asset, this marital home, then husband's on the hook for that dollar amount. But she did get the home. She did sell the home. She did get all of the proceeds from that home. So the terms as contemplated by the parties when they entered a marital settlement agreement that wife gets the home as part of equitable distribution occurred. The legal mechanism of the writing of the deed that was at no fault of the former husbands didn't accomplish what he thought it did. And when he found out that it didn't accomplish it, he corrected it. So again, we're in a position that the court in an abuse of discretion case had factual basis and had legal basis in which to enter the order that it did. In addition, under Tipsy Coachman, it had multiple other manners in which it could have come to the same ruling. And as a result, we ask that this court affirm the trial court order that is previously put in place. If there's no further questions.
Okay. Mr. Tyson, you may proceed.
Thank you, Your Honors. I'll address quickly the argument of the Tipsy Coachman applying in this case. The 2014 agreement had nothing to do with the liquidated damages clause. I think it was abundantly clear, and that's why I think the trial court didn't even address it. So Tipsy Coachman doesn't apply because I think Appellee's counsel is asking this court to make factual findings at this level, at the appellate level, regarding what the party's intentions were on this other agreement. So it's an irrelevant. That 2014 agreement is irrelevant to the issues before the court today. And so this court is not in a place where it can now substitute its findings on the intent of a contract here at the appellate level. So it's not appropriate at all in this circumstance. Appellee's counsel kept talking about what the wife didn't do and the wife's actions. I think Judge Harris was alluding to the fact that this agreement was clear cut. To make the assertion that he complied in 2013 because he just signed a deed and that's all that he had to sign. That argument wasn't even made at the trial court by the former husband. I think everybody acknowledged during the trial that the deed wasn't properly prepared in accordance with what the parties agreed to. But you have a situation where there was a heavy, stiff penalty. Obviously, the parties felt it important when they entered into this agreement to put this penalty provision in there. And we can't second guess why they did it, but this was an important issue and it was a severe penalty. Given the severity of the penalty, I thought it should be incumbent upon the husband, the former husband, to make sure that he's doing everything he can. I know if it's, in general circumstances where you're facing a heavy, heavy penalty with very serious potential legal consequences and potentially having to pay $200,000, it behooves somebody to make sure that they dotted their I's and crossed their T's. And the reality is he did it. And an important fact that came out during the trial court is when the former husband filed for bankruptcy in 2019, he listed the property, this property that we're talking about, on his bankruptcy petition. It was brought up. It was an undisputed fact at the trial court. So to take the position that I did what I did in 2013 and I thought I was doing it right, no, you didn't, because in 2019 you asserted the property was still half yours. And the marital settlement agreement is unambiguous. We could twist it. We could turn it. We could all give our own 5 different interpretations of what everybody wanted out of it. That's not the place of the law. The place of the law is this is the parties' agreement. It's clear. He was supposed to transfer his interest within 60 days. He didn't do it. It took him 10 years to do it. If he didn't do it, these are his damages. We could all question whether it's a good deal, bad deal. It doesn't matter.
Mr. Tyson, couldn't we similarly find that the 2014 agreement is unambiguous? It says any and all alimony payments. At the time that was signed, this alimony penalty would have already accrued. Why do we have to look into their intent? It says any and all alimony payments.
Because the trial court interpreted the alimony provision not as alimony. In this case, it interpreted it as a property distribution. So clearly the alimony in the 2014 agreement related to the other alimony, because there was 2 types of quote unquote alimony in the agreement. So the trial court herself interpreted the alimony to not be alimony. So I don't know how we can make the leap and say that 2014 was property as well. I think we're getting far afield. The issue is very clear. The issue is very clear. There was an agreement. It was breached. These are the damages. And the important distinction is it was adopted into a final judgment. And once it was adopted into a final judgment, that agreement, which may have been voidable, is no longer challengeable. And that's pursuant to Palmer and the 2022 case of Atunis. That's in my brief. It says once it becomes a marital settlement agreement, gets adopted into a final judgment, it becomes enforceable, even if it's a penalty provision under a contract. So in closing, this is a simple issue. The trial court should have simply entered a judgment for what is owed, calculated the interest, and sent the folks on their way. Thank you, Your Honors.
I was muted. Thank you, counsel. Thank you for your argument, and we are adjourned. Have a great day.
Thank you, everyone.